You can find that quotation about knowledge, skill, experience, training, or education in Rule 702 in the Federal Rules of Evidence. The rule also specifies that the expert witness has to apply that knowledge and those skills in ways to qualify both you as the expert and your work. First, you must base your testimony on, quote, sufficient facts or data, end quote. As an expert witness, you have to convince the court that those facts provide a solid basis for your opinions. You may not just rely on instincts or simply your experience in the industry. Let's talk a bit about a key federal rule of evidence, number 702. You have to determine what set of facts and data will support any conclusions you reach. To guide you, Rule 702 adds that your testimony must be, quote, the product of reliable principles and methods, end quote. As an expert in the field, you should already be familiar with the principles and methods used by others in your field. You will have to reference and explain any commonly accepted rules, standards, or guidelines that govern your industry. Finally, the rule dictates that you have to have, quote, applied the principles and methods reliably to the facts of the case, end quote. The current wording in Rule 702 of the Federal Rules of Evidence regarding testimony by experts has its origins in the rulings from three well-known legal cases: Daubert versus Merrill Dow Pharmaceuticals in 1993, General Electric versus Joyner in 1997, and Kumho Tire versus Carmichael in 1999. You will hear the name Daubert frequently when speaking with attorneys. Attorneys must anticipate the standards imposed by Daubert when they select expert witnesses in support of their cases. An important tactic for you to use. Understanding Daubert and its implications on your performance as an expert increases your chances that attorneys will hire you. The attorneys and you must both anticipate legal challenges to the acceptability of their investigations and analyses. Daubert standards and challenges guide what you as an expert witness must understand and how you as an expert witness should conduct your investigations, testing, and analyses. These teachings will explain how to apply the appropriate standards for reliable methodologies in expert witness work. You have to understand that you as an expert witness are part of a team. Competitive sports have sides, one opponent against another opponent. Lawyers admit that the judicial arena is also adversarial. While a trial is not a game, gamesmanship is involved. You can play in a pickup game, but it takes advanced skills to play in the major leagues. No matter what your specialty, becoming an expert witness in your specialty is the major leagues for you. There's not necessarily a good team or bad team, or a right team or a wrong team, but there are always sides. Each side wants to win, and sometimes a weaker side wins. In the legal arena, lawsuits involve at least one plaintiff and one defendant. The jurors or the judge often rely on experts to help explain and clarify complicated facts. A bench trial occurs when a trial has no jurors and the judge delivers the final verdict of guilt or innocence. Let's take a look at some of the issues involved from both sides now. Either the defense or the plaintiff may hire you as an expert witness, but experts sometimes choose to work only for the defense or the plaintiff. In criminal cases only, we refer to the party that brings the lawsuit as the prosecution. In civil cases, the plaintiff is the party that brings the lawsuit. I'll refer throughout my lessons to plaintiffs as the party that brings the lawsuit, rather than complicating the text by constantly referring to either the plaintiff or the prosecution in civil or criminal cases. Experts who always work for one side or the other have reasons, as you may, for choosing to do this. However, this will restrict your choices and your future work. An important tactic to remember is that judges tend to look favorably on experts who show a balanced approach to litigation support. Always working for defense attorneys or for plaintiff attorneys does arguably tend to suggest bias toward one side or the other. I have found that attorneys perceive me as objective because I've worked on both sides of cases. This in turn has led to more casework. Attorneys for the defense say fondly that defendants are entitled to a legal defense and are innocent until proven guilty. In the same fashion, you as an expert witness can offer your objective analytical skills to attorneys on either side of any case. You do not resolve the right or wrong of a case. You just have to bring your expertise and knowledge to the court. You have to present your analysis and your findings, and then provide impartial testimony. Let's take a brief look at some other legal settings beyond the courtroom. Attorneys retain experts in three principal settings: courtroom trials, mediations, and arbitrations. My lessons rely on my experience in courts and in litigations that often lead to a courtroom trial. However, my advice on preparation and presentation, and my tips and techniques for giving testimony apply equally well to each of these three possible settings. In mediations, a judge or retired judge often work to negotiate a compromise. In arbitrations, the parties may agree in advance to accept the arbitrator's findings as binding. You can offer your expert services in these settings as well as in courtroom-based settings. If offering testimony in mediations or arbitrations appeals to you as a way to expand your business, then you can consider contacting mediation or arbitration service organizations. Let them know of your availability to work with them as a specialist in your field.